Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. And in this video, we're continuing our series on the E-2 investor visa by taking a look at where to apply for the visa, whether at a consulate or at U.S. Citizenship and Immigration Services, or USCIS, from within the U.S. We'll discuss the pros and cons of each option and the key pieces of information that any E-2 investor applicant will want to keep in mind. Before we dive in, if you're interested in more information about the E-2 visa requirements, we've posted to our YouTube channel our full webinar on the E-2 visa. We also share a lot of free information about the E-2 visa and other visas on our blog. We'll link to both our blog and our YouTube channel below. Finally, please remember that no video or blog post can replace the value of working directly with an immigration lawyer who can navigate the specific nuances of your application. So let's take a look at what to keep in mind when deciding whether to apply for an E-2 investor visa through USCIS or at a consulate. Let's start with the fundamental question of who can apply where. Pretty much everyone can apply for an E-2 investor visa through a consulate in their home country. It doesn't matter whether they're currently inside the US or outside it. The consulate in the applicant's home country is almost always an option, and applicants who are outside the US must apply at a consulate. USCIS, on the other hand, is only an option for those who are inside the US. If you're inside the US on a student visa or a visitor visa, for example, then you would generally have the option of applying for E-2 status either through USCIS or at a consulate abroad. The process of applying for E-2 status from within the US is called changing status, since you're in the US in one status and are applying to change to E-2 status. However, some people in the United States are not eligible to apply for a change of status through USCIS. These include those who are in the U.S. on the Visa Waiver Program, or ESTA, those who are on a J-1 visa that's subject to the 2-year home residency requirement, those who are not in valid status, such as if they overstayed or otherwise violated the terms of their visa, and those who are subject to an entry bar. All of these individuals must apply for an E-2 visa through the consulate in their home country. Additionally, those who are in the U.S. may also be able to apply through the U.S. Consulate in Toronto. The Consulate in Toronto is an option for non-Canadian citizens who are residing in the United States. Residing in the U.S. includes living in the U.S. on a non-immigrant visa, such as a student visa, for example. It's not limited to those who are permanent residents in the United States. If you've been residing in the U.S. and will continue to do so at the time the E-2 application is submitted, you can usually submit your application to the consulate in Toronto. As soon as the individual's status in the U.S. expires and they leave the U.S., though, they would no longer be residing in the U.S. and therefore would be unable to apply for the E-2 visa at the consulate in Toronto. This is a good point to pause and highlight a critical difference between the consulate and USCIS. Only a consulate can issue an E-2 visa, which is necessary to travel into and out of the US. USCIS cannot issue a visa. They can only grant status. This allows the person to remain inside the United States, but as soon as they leave, they'll need a visa to re-enter. And a visa, as we mentioned before, can only be issued by a consulate. Let's take a look at how the application process is different between USCIS and a consulate. The first step to apply for the visa at a consulate is to complete the online DS-160 form. You would then submit your supporting documentation to the consulate showing that you satisfy all of the E-2 visa requirements. We get into the details of these requirements in our YouTube series on the E-2 visa, so please do check that out if you're interested. Once the DS-160 and supporting documents are submitted, the consulate might ask for additional information before scheduling the applicant for an in-person interview. The interview gives the officer an opportunity to ask any questions they have about the investor or about their E-2 business, and the officer will usually approve or deny the application at the interview. If approved, the visa will be added to the applicant's passport, and they'll then be able to enter the U.S. in E-2 status and to start developing and directing their E-2 business. The validity period of the E-2 visa will be between 3 months and 5 years, and will depend on both the officer's discretion and the reciprocity agreement that the United States has with the country of origin. If applying for E-2 status through USCIS, the applicant must complete and file a Form I-129, along with supporting documents showing that they qualify for the visa. USCIS provides the option to decide the application in 15 calendar days for an additional premium processing fee of $2,500 as of the time of this video. Once the application is submitted, USCIS can respond with an approval, a denial, or a request for additional evidence, or an RFE, if they have any questions about any aspect of the application. No interview is required through USCIS. Once approved, the government will send an approval notice which grants E-2 status for 2 years. As long as the applicant does not leave the U.S., they can renew E-2 status indefinitely, as long as the business and the E-2 investor remain eligible. One note about timing. As long as the applicant submits the I-129 to USCIS before their Form I-94 expires, they can remain in the U.S. until USCIS decides their application. This time is not counted against them as long as they timely filed the I-129 before the I-94 expires. So how do you choose between applying at a consulate or USCIS? In most cases, it's recommended that the E-2 investor apply at a consulate. Let's talk about why a consulate is often preferred over USCIS. First, if the application is approved, the consulate will issue an E-2 visa, rather than just E-2 status. A visa will enable the applicant to travel into and out of the U.S. An approval of E-2 status by USCIS allows the person to stay in the U.S. for up to 2 years, but the minute they leave the U.S., they'll need to apply for an E-2 visa to re-enter. As a result, filing a change of status petition with USCIS is generally only a temporary solution for most applicants who will eventually want to get an E-2 visa. As soon as the investor decides to apply for a visa at the consulate, an entirely new E-2 application is required. The consulate is not required to defer to an approval by USCIS, and they will require reviewing and adjudicating the application new. Consulates also tend to spend much less time reviewing the source and trail of funds invested into the business, and are usually satisfied if it's clear that the money came from a legitimate and legal source. USCIS, in contrast, will require an accounting of each dollar invested into the E-2 business, tracing it from its source to the E-2 business. For USCIS change of status filings, the applicant must include much more detailed documentation about the source and transfer of funds into the E-2 business. USCIS requires receipts and proof of payment for every single expenditure made for the E-2 business. Therefore, in situations when the investment was made a while ago and the applicant can't assemble all the necessary documents, applying at a consulate may be a better option. USCIS also may issue a request for evidence, or RFE, asking for additional documentation showing where the funds originated and how they were transferred into the E-2 business. For more information about the source of funds requirement, check out our separate YouTube video on this requirement. The filing fees for the consular filing are also usually much lower than the filing fees imposed by USCIS. Usually the cost to file at a consulate is $205, though an additional reciprocity fee could be applied. For just the E-2 investor, USCIS charges the I-129 filing fee, which is currently $460, plus the optional premium processing fee of $2,500 if the applicant prefers an expedited decision. Any dependents, including a spouse and children, will require additional filing fees. While USCIS guarantees a response within 15 calendar days if the applicant chooses to pay the premium processing fee, the normal processing time at some consulates is not that much longer. Consulates can issue E-2 visas for up to 5 years, whereas USCIS is limited to granting E-2 status for a maximum of 2 years. This could be particularly relevant for a startup. When the business is a startup, the difference between 2 years and 5 years can be substantial, with 2 years being little time for the business to establish its operations, revenue, and hiring. For most startup businesses, the applicant can provide a 5-year business plan to satisfy the requirement that the business generate income and employ U.S. workers. The consulate would then typically provide a visa with a 5-year validity period, giving the applicant 5 years to achieve its projections. If the applicant decides to apply for a change of status through USCIS, then applies to a consulate, the consulate will factor in the time the business has been operating in the U.S. If the first 2 years have not gone as planned, which is common among startups, which could require more time to get off the ground, this could count against the application, causing the officer to question whether the business is likely to achieve its income and hiring projections. When an applicant files a change of status application, they must show that they have maintained status and not violated the terms of their visa while in the U.S. This gives USCIS a broad opportunity to question whether the applicant has maintained status. Proving that you maintain status is not a formal requirement for consular filings. So, given all of that, why would someone choose to apply through USCIS? Well, there are a number of good reasons. First, we saw a huge increase in the number of E-2 applications filed with USCIS as a result of the COVID-19 pandemic. The pandemic prevented many people from traveling back to their home countries, making a consular application almost impossible. Also, the backlogs created at many consulates as a result of the reduced staffing levels became prohibitive. For those who do not want to leave the United States, applying with USCIS is the best and maybe the only option. If you're currently in the U.S. and you want to start running your business as soon as possible, filing a change of status application with the premium processing option could be ideal. The premium processing fee of $2,500 is worth it to many applicants who want a decision from USCIS within 15 calendar days. As soon as the petition is approved, you can start working for your E-2 company. Even if you choose not to pay for the premium processing service, as long as you file the change of status petition before your current status as stated on your I-94 expires, you'd be able to stay in the U.S., but not work in E-2 status for as long as the change of status petition is pending. USCIS is currently requiring several months to decide E-2 applications without premium processing, but you also always have the option to request premium processing and pay the additional premium processing fee later if you decide that you want to know the decision sooner. Applying for a change of status through USCIS can also be a great option if your country's reciprocity schedule only grants you the visa for several months. Remember that the amount of time the visa is issued for depends on the reciprocity agreement that the United States has with the home country. In some countries, the visa is issued for as little as 3 months. For nationals of these countries, the 2 years of status provided by USCIS could be preferable. If they leave, they then need to get a visa to come back into the U.S. But keep in mind that E-2 visa length only governs the time period that you have to enter the United States. Once an applicant enters the country, they're given 2 years in E-2 status even if they enter on the last day of their E-2 visa. USCIS is also often recommended when the applicant has invested a lower amount into the business. Our experience has been that USCIS applies the law with respect to investment amount fairly consistently and doesn't deny applications solely based on the investment amount being low. This could be because USCIS decisions can be appealed and the applicant is afforded due process when they're inside the U.S. It's worth noting that while adjudication at consulates may not be as consistent as USCIS, consular officers are rotated every 2 years. As a result, a good consulate may be a bad consulate over time. Applying at USCIS could also be the best option if you have a pending green card application, since a consular officer or border official could determine that the applicant does not intend to depart from the United States at the end of their E-2 visa. For more information, check out our video that's focused on the E-2 intent to depart requirement. If you have an immigrant petition outstanding, you should speak to a qualified immigration attorney to carefully navigate through that process. Finally, some clients ask whether it's possible to file at both a consulate and USCIS at the same time. The answer is yes, and there can be strategic reasons to do this. If you're already in the US, this would allow you to start working for the company as soon as USCIS approves the petition, which could be as quick as 15 calendar days if you choose premium processing. You could then attend the E-2 visa appointment once the consulate schedules the interview. Once approved, you'd then be able to travel into and out of the US with your E-2 visa. We hope this video about the pros and cons of applying for an E-2 investor visa at USCIS versus at a consulate was helpful. If it was, please click the like and subscribe buttons below to stay updated on future videos about visa options and travel to the US. Thank you for watching.